Hearings on due process complaints. Impartial due process hearing, 34 CFR Section 300.511. Whenever a due process complaint is filed, the parents or adult student or the LE involved in the dispute must have an opportunity for an impartial due process hearing. The USP State Director of Special Education shall monitor all due process hearings to ensure adherence to required procedures. Impartial Hearing Officer. The impartial due process hearing shall be conducted by the USP. The USP State Director of Special Education or designee shall assign an impartial hearing officer on a random, rotation, basis, and in accordance with USP procedures. At a minimum, a hearing officer must 1. Not be an employee of the USP or the LE that is involved in the education or care of the student, or 2. Not be a person having a personal or professional interest that conflicts with the person's objectivity in the hearing. 3. Possess knowledge of, and the ability to understand, the provisions of the IDEA and USP special education rules, federal and state regulations pertaining to the IDEA, and legal interpretations of the IDEA by federal and state courts. 4. Possess the knowledge and ability to conduct hearings in accordance with appropriate, standard legal practice, and 5. Possess the knowledge and ability to render and write decisions in accordance with appropriate, standard legal practice. A person who otherwise qualifies to conduct the hearing is not an employee of the agency solely because he or she is paid by the agency to serve as a hearing officer. Subject matter of due process hearing. The party requesting the due process hearing may not raise issues at the due process hearing that were not raised in the due process complaint, unless the other party agrees otherwise. Timeline for requesting a hearing. A parent or adult student or LE must request an impartial hearing on their due process complaint within 2 years of the date the parent or adult student or LE knew or should have known about the alleged action that forms the basis of the due process complaint. Exceptions to the timeline. The timeline described in Rule 4M.6 does not apply to a parent or adult student if the parent or adult student was prevented from filing a due process complaint due to 1. Specific misrepresentations by the LE that it had resolved the problem forming the basis of the due process complaint, or 2. The LE is withholding of information from the parent or adult student that was required to be provided to the parent or adult student. Hearing rights. 34 CFR Section 300.512. General. Any party to a hearing or an appeal has the right to 1. Be accompanied and advised by counsel and by individuals with special knowledge or training with respect to the problems of students with disabilities. 2. Present evidence and confront, cross-examine, and compel the attendance of witnesses. 3. Prohibit the introduction of any evidence at the hearing that has not been disclosed to that party at least 5 business days before the hearing. 4. Obtain a written or, at the option of the parents or adult student, electronic, verbatim record of the hearing, and 5. Obtain written or, at the option of the parents or adult student, electronic findings of facts and decisions. Additional disclosure of information. At least 5 business days prior to a hearing, each party must disclose to all other parties all evaluations completed by that date and recommendations based on the offering party's evaluations that the party intends to use at the hearing. A hearing officer may bar any party from introducing the relevant evaluation or recommendation not disclosed at least 5 business days prior to the hearing without the consent of the other party. Parental rights at hearings. Parents or adult students involved in hearings must be given the right to 1. Have the student who is the subject of the hearing present. 2. Open the hearing to the public, and 3. Have the record of the hearing and the findings of fact and decisions provided at no cost to parents. Hearing decisions. 34 CFR Section 300.513. Decision of the hearing officer. A hearing officer's determination of whether the student received a FAPE must be based on substantive grounds. In matters alleging a procedural violation, a hearing officer may find that a student did not receive a FAPE only if the procedural inadequacies 1. Impeded the student's right to a FAPE. 2. Significantly impeded the parents' or adult student's opportunity to participate in the decision-making process regarding the provision of a FAPE to the student, or 3. Caused a deprivation of educational benefit. Nothing in this section shall be construed to preclude a hearing officer from ordering and LE to comply with procedural requirements. Separate request for a due process hearing. A parent or adult student has the right to file a separate due process complaint on an issue separate from a due process complaint already filed. Findings and decision provided to the advisory panel and general public. The USP State Director of Special Education, after deleting any personally identifiable information, must 1. Transmit the findings and decisions on the due process complaint to the Utah Special Education Advisory Panel, USAP, and 2. Make those findings and decisions available to the public online. Finality of decision. 34 CFR Section 300.514. A decision made in a hearing conducted is final unless a party to a hearing appeals the decision to a civil action. State enforcement mechanisms. 34 CFR Section 300.537. Notwithstanding the provisions for judicial enforcement of a written agreement reached as a result of mediation or a resolution meeting, there is nothing that would prevent the used from using other mechanisms to seek enforcement of that agreement, provided that use of those mechanisms is not mandatory and does not delay or deny a party the right to seek enforcement of the written agreement in a state court of competent jurisdiction or in a district court of the United States. Timelines and convenience of hearings. 34 CFR Section 300.515. The used State Director of Special Education or designee must ensure that not later than 45 calendar days after the expiration of the 30 calendar day resolution period, or the adjusted time periods resulting from the resolution process, 1. A final decision is reached in the hearing, and 2. A copy of the decision is mailed to each of the parties. A hearing officer may grant specific extensions of time at the request of either party. Each hearing and each review involving oral arguments must be conducted at a time and place that is reasonably convenient to the parents and student involved. Expedited due process hearings. Expedited due process hearings may be requested by either a parent or adult student or only in the following instances. Section 300.532. 1. The parent or adult student disagrees with any disciplinary decision resulting in a placement, including the interim alternative educational setting, IES, decision, or the manifestation determination. 2. The LEAP believes that maintaining the current placement of the student following a disciplinary procedure in Section 300.530 and Section 300.531 is substantially likely to result in injury to the student or others. Expedited due process hearings must occur within 20 days of the date the due process complaint is filed, in compliance with the due process requirements of 4J. The hearing officer must make a determination within 10 school days after the hearing. Unless the parent or adult student only agree in writing to waive the resolution meeting or agree to use the mediation process described in Section 300.506, a resolution meeting must occur within 7 days of receiving notice of the due process complaint, and the due process hearing may proceed unless the matter has been resolved to the satisfaction of both parties within 15 days of the receipt of the due process complaint. Within 15 days of the receipt of the due process